Howdy, and welcome to the show. Cooper's Code focuses on legal issues and notable practitioners, distilling wisdom so we all achieve the best results for our clients. I'm Miles Cooper. Thank you for joining us for part 2 of Kevin Morrison's interview. For those of you who have not had an opportunity, please feel free to listen to last week's part 1 and enjoy the show. Going back to your work with Jones Clifford, from an outsider's perspective, when I think of Jones Clifford, I think of another one of the preeminent firms for workers' comp, third-party overlap, with kind of a heavy influx of police and firefighters. Am I accurate on that?
You nailed it, 100%. Yeah, they predominantly a workers' comp firm. Their bread and butter was CHP, plus some other associated police agencies, Oakland Police, San Francisco Fire, San Francisco Police, a few other agencies. And so, and then some other cases as well. And then they had a couple of PI lawyers taking the inevitable spin-off of those comp cases. Classic Jones Clifford case is a CHP officer on the side of a road and truck driver, doesn't control his vehicle, hits the CHP officer, so the CHP officer sues the truck company. That's a classic case. So a lot of that kind of stuff. So yeah, a lot of police officer plaintiff clients, which is interesting.
So when you are there, you're I would say you're fairly established as a lawyer. Are you bringing your own types of cases in terms of ironworker, construction cases when you're coming over from Bell's office, or are you picking up some of the CHP cases, kind of a combination?
Combination. I brought some files over with me with Stan's blessing. We worked out an arrangement, did all up front. Here's what we're going to do. Here's the arrangement. Great. Here you go. So I brought some cases over with me. I did have some connections with some ironworkers. That's extremely union-based, and I didn't have any connections with any union folks, really. So any construction cases I got was from former client stuff, which did happen from time to time, and a lot of CHP officer, police, and fire stuff, and then kind of word-of-mouth cases from defense attorneys, friends, family. That was how I got the cases at Jones Clifford, I would say.
And you mentioned you may have done a med mal, one or two, not your thing. Of the things that are your thing, was there a particular niche that you liked or something that you gravitated to, or was it all comers?
Pretty much all comers. I like bike cases. I like truck cases. This is going to sound warped, but I am passionate about wrongful death cases. It's such a devastating time for people, and to be able to bring some peace, some level of accountability for anybody who's suffered the ultimate loss is so rewarding. So I really feel good in those cases.
Would now be a good time to talk a little bit about the UPS case?
Sure.
For those who are not familiar with the UPS shooting incident, can you help lay the foundation, to use a lawyer phrase, so that we can help understand a little bit about the magnitude of the incident, the loss, and then the ensuing litigation?
Absolutely. So on June 14th, 2017, UPS worker walked into the UPS distribution facility, and I walked through a metal detector, and about 8 or 9 minutes later, shot and killed 3 co-employees, shot but wounded 2 others in front of 50-ish plus employees. It happened at a morning meeting. And so people obviously were terrified, running for their lives, locking themselves in bathrooms, thinking they were next, hiding under trucks, in trucks. Police responded pretty quickly, and the shooter took his life when confronted with the police.
When did you get involved?
Pretty shortly thereafter. I was contacted by someone who was very close with one of the family members who was killed. The referral came to me from a defense attorney who I litigated against a couple of years ago, and we just got along. And me and my partner, Josh White, met with one family And before I knew it, the summer of 2017 was meeting with a whole bunch of people who suffered a whole bunch of loss.
And when you describe a whole bunch of loss, we started going down this path when we talk about wrongful death and helping a family who's lost a loved one. But obviously being witness to this kind of an event also has significant consequences for those involved. What types of stories, interactions were you hearing from people?
A lifetime of stories and interactions and horror. First of all, you got the folks who were shot and killed, and the families absolutely devastated by that. The two folks who were shot but survived. When think you're going to bleed out, you're walking yourself to General Hospital. It's complete mayhem. You can imagine what it's like. You got helicopters, police, ambulances. Trying to get to General Hospital was difficult. You got folks who are watching the shootings and are hiding under trucks. You got folks who are hiding in the bathrooms and the bathrooms that don't lock. So you can imagine any commercial building, and you walk into the bathroom, it doesn't lock, and so they're in stalls with their legs up because they think the shooter's going to come in there, and they don't know what's going on. They hear gunfire outside, and so for a half an hour, they're in the bathroom stall, and the police are clearing because they don't know. The police have no idea if this is a coordinated effort or there are multiple shooters. So they storm the bathroom, thinking these guys could be shooters, and hands up on the floor. Maybe the police are going to shoot us. I mean, those kinds of stories. I mean, some of these clients who had PTSD. I'll never forget the story of one person who, he observed the shootings, observed his friend get killed. Obviously, was in therapy for a while, and part of the therapy is slowly exposing yourself to the event. The worst part was that these folks had to go back to work. They had to go back to the scene of the crime.
Right.
And so part of the therapy was exposing him or others slowly to, okay, we'll drive around the building once and then we'll go back to, that kind of thing. This guy he would start to walk to the building. He would vomit. He could not see the building without going into, complete terror and depression, the nightmares. These folks were absolutely traumatized. And they're incredible people, and it was an honor and a privilege to represent all of them. It was really, it's one of those cases that you'll never forget.
I'm going to kind of lead in so that our listeners can understand some of the oddities in my questioning.
Sure.
Which is, some of this case went to trial, correct?
Yes.
I'm now doing it cross-examination instead of direct.
Yes.
There is no verdict, correct?
Correct.
Which means that there was a resolution at some point.
There was a resolution. So the case was litigated. We started taking depositions just before the pandemic. I think we took 5 or 6 before the pandemic, and then the pandemic happens and everybody shuts down. We don't know what's going to happen. And then pretty quickly, because we had a trial date, we started depositions again, and we started remote, right? That's how you started doing depositions. And so within a couple of months of the pandemic, we were taking a whole bunch of remote depositions. And by a whole bunch, I mean, there were 222 depositions taken in that case.
Wow.
Not that I counted. 2 discovery referees. Everything was a dispute. It was, to call it hard fought is an understatement. There were a couple other law firms. So one law firm represented one of the other, the folks, one of the gentlemen who was killed. And then another law firm represented kind of half of the survivors of a death case. Those folks resolved. And we went to trial in the fall of 2021. And took us a week to select a jury. And after 5 weeks of trial, the day before closing argument, the case resolved.
The case resolved confidentially. That's the punchline in terms of my delicate questioning, and you'll set me straight if I step over the line on any of this. So
it did resolve confidentially, yes.
In that vein, just taking us back to the incident itself, when I hear a shooter and I hear a workplace shooting, the first thing that comes to mind is, okay, well, that's all workers' comp. That's exclusive remedy, unless the shooter happens to be Bill Gates and personally wealthy or what have you. How did you and your team start working through the case to determine, is there somebody who may be responsible outside of the shooter himself?
Yeah, we obviously did some investigation, but we did determine that there was a viable third-party defendant, and that's about all I can say, I think.
For anyone who has questions about the facts themselves, Googling UPS shooting San Francisco will get you a Wikipedia entry that will be very specific in terms of what has come to pass as far as this is concerned.
Yeah, I think that's probably right.
221 depositions.
222, Miles.
222, I'm sorry. I undercount sometimes. How did you manage that level of information and mastery of information? And the you is collective, because I don't expect that it is just Kevin Morrison on this case in terms of getting it ready for trial. But that's a lot of material to keep track of in order to put on the show. How did you do that?
See this gray hair? Rewind to 2018. I didn't have much gray hair. I mean, literally, it was an incredible logistical management challenge. So, there's the litigation part, which I think I'm pretty good at-ish. And there's the managing basically a mass tort almost, which is a completely different animal and takes a different skill set. And so
I'm going to ask you some specifics on this. So I presume you're in complex.
Yes.
But again, this is kind of the nerd side on management of material. Are you using just a standard like Windows Explorer file share? Are you using a document management program? Are you using case management software? 222 video depositions is a ton of data. And once you start getting into the transcripts and the syncing and the getting the excerpts that you want to play, let alone all the other documentary evidence, how does your firm manage that material in a manageable way?
Yeah.
And the more granular you can get on this, for those of us who are trying to understand how you manage large amounts of information, would be fantastic.
Great question. I'll do my best. I am not a tech person.
I'm understanding that limitation.
Yeah. And there was a system in which I forgot how many gigabytes of files that was produced to us by the defense of the case, just the written volumes of written material. So that's one massive amount of information. And there was some system that would help sort, and you could sort through that stuff and search for words and that sort of thing. And forgive me for my lack of technology. I don't remember that system. So that was helpful. I had a paralegal at the time. She's now an attorney, Monica Law. She's incredible. She was responsible for that for our firm. And then my partner, Josh White, and my partner, Craig Peters, handled the case with me. Craig did a lot of the liability part. Josh handled a lot of the discovery and for our plaintiffs. So we had 56 clients when you added up all the survivors and the loss consortium folks, and so it was just a lot of medical records and interrogatory responses and wage loss documents, and so it was a ton of stuff to manage. And so it was a group effort with a great paralegal, with two great partners, myself. The other attorneys, the other firms were great until they resolved, but ultimately it was us that tried the case. And we used, Cogent was helpful with the trial tech aspect, but I'll never forget the depo designation conference that we had with our trial judge, Judge East. And so we designated our depos that we wanted to play, and the defendants objected to every question. When I say every question, I mean they objected to what is your name? Because that calls for speculation, lacks foundation.
Was that we don't have time or resources to adequately assess what we're objecting to, so we're just objecting to everything?
Apparently. They went to they took the time to do an objection to our depo designations. They put objections to each question, including what is your name. So yeah, I think so. And so we get to a depo designation conference with the trial judge. And so we're going back and forth, and the trial judge is understandably going out of her mind, ruling on objections like these. And
sometimes there kind of becomes a clear winner and a clear loser in the, oh my God, you are unreasonable.
mm-hmm.
Sometimes just being near an unreasonable person, you get tarred with the unreasonable brush.
Yeah.
How are things going for you in the courtroom as far as that's concerned?
I think the judge saw what was going on. Initially, I think she was probably, before we started trial, she had some questions about our case, got some unfavorable rulings and motions eliminate, which she always do in every single case. I frankly thought some mistakes were made on on the mills, but that's okay. That's what happens before trial. I think once she kind of saw us in trial, jury selection, and how we handled ourselves, and how the other side handled it themselves, I think she kind of started seeing what was going on, and the trial rulings, went fairly well, and she did a great job handling the case. It was high profile. This is Judge Rochelle East. It was a lot of pressure. It was during the Delta variant, so we tried the case in mass. After hardships, 200 survived hardships. We'd written questionnaires for 200 folks. So 200 up in the 602, 604 courtroom that you can in San Francisco Superior Court that combines into one massive courtroom. So we got distancing, we got mass sound, we got 200 questionnaires to go through. We got an 18-pack. So it took a week to pick the jury. A lot going on there. Defense had two trial consultants at their bench. We had one. Took a long time to pick a jury. And so then once the trial started, we moved to her department 606, much smaller. A lot to manage. And I think once we started trial, it seemed like we were making some momentum.
Who do you use for trial consulting?
Carol Baus, primarily. I've used Sonia Chopra, who's great. Carol Baus has been my go-to for quite a while.
As far as follow-up is concerned, and I recognize the case settled, did you say just before closing?
Day before.
Okay.
So it settled at lunch the day before closing.
Were you at Tommy Toys?
No, I was at Max's. This is Delta. There was two restaurants based in the Civic Center open at this time. So I was at Max's, and before lunch, I was cross-examining the defense expert, and he hands me a note card saying, there's an offer for X that expires today. I'm like, oh, okay. So I asked a couple more questions. We break for lunch. I'm like, oh my gosh, and the way, because there were so many plaintiffs, we had authority for a certain number globally, if that makes sense. So we knew all these cases are individual cases, and they're all worth different amounts of money. And we had written authority from our clients for nothing less than X. And so when you add all those numbers up, we knew what the global number was. And so we were Josh was doing the negotiations during trial. Judge Bradstreet at the time was still on the bench. He was doing negotiations during trial. Josh was primarily involved with that. And so they finally got to a place where we were north of the number. And so, but the next day, so we settled, so we have lunch at Max's. Okay, come back tomorrow. I want to put this on the record. I want all your clients here. So we're talking 56 people, right? And some of them are, so literally that afternoon, that evening, the effort it took to get all of our clients, and talking to Loss Consortium clients too, to be present the next day and Zoom in open court to go over the terms of the settlement and for them to assent. That was a Herculean effort. Again, Monica Law, Josh White, myself were, making sure the clients could all be there. We had one guy literally in his truck assenting to the terms of the settlement. So I actually had tears in my eyes watching that, because that was the end of this journey, the end of litigation journey that became such a big part of our lives. For 4 years, these people were family almost to us. I mean, family really. I got really close with a lot of those folks, and I had great empathy for what they went through, and I have great affection for them. They're really our heroes. When that can happen to you, something at work can happen to you like that. When you're sitting in your office and your friend gets blown away in front of you, and you can have the courage to eventually go back to work. I mean, there aren't any words really for that. And I'm just talking about the PTSD folks and the families that lost dads and husbands. I mean, just remarkable people. Without exception, the clients were so grateful that we were involved, so grateful for the fight. Thank you so much for taking this on. I mean, without exception, incredible people.
We started down this path in terms of you talking about, one of your favorite types of cases to work on in terms of helping people through the ultimate loss or wrongful death. And I would be remiss if I didn't ask you about the damages side in a wrongful death case, because those cases are unique. The most important evidence is no longer around, and how do you tell that story? And so that's a lead-in on the death side of things, whether it's the UPS case or others. If you were to be providing advice to younger lawyers about how they build the damages side in a death case, are there certain tools that you have found to be more effective than others as you build these stories?
Yeah, great question. So we always focus on the non-economic loss. The economic loss, we usually end up not even claiming it anyway at trial. And so it's the non-economic damage. And of course, that's the thing that matters when you lose somebody. It's the loss of time with your father, the fact that you're not going to walk your daughter down at her wedding, the fact that you're not going to, have a cup of coffee with them, all that stuff, not going to be there for the birth of your child. And so you need to, it just comes down to like any case really, but even more in death cases. First of all, they're obviously distraught, worst time of their lives. They're emotional. It takes a lot of time, and time meaning in their house time, at their kitchen table time, going through photo albums time, not calling Zooms and stuff. To the extent that they're open to that, there's going to be a time where they don't want to see you for a while, perhaps. But once they start to get to know you, it requires time with them. You need to get to know their stories, who this person was, and bring them to life through coworkers, friends, colleagues. So you find out who that person was before cards. Hopefully there's emails. There's, who knows, hopefully there's evidence of the relationship. So it just takes a lot of touches, time with it, minutes, hours with the clients to get to know the person who passed. So you can tell the story and what that person meant to your client and what that relationship means. You can tell stories and point to evidence that shows the jury the strength of their relationship.
It's an abrupt pivot, not a smooth segue. And I don't know that there's an easy way to move on from that piece. The type of firm that objects to questions like, what is your name, as being speculative, and a case where you have 2 discovery referees and 222 depositions. I got the number right, I think, that time.
You did.
How do you, either as a person, as a firm, or as a collective firms, handle what sounds like it might have been a scorched earth defense?
With great difficulty. I like to think I get along with most folks and pride myself on getting along with my opponents. They're my opponents, not my enemies. And I think I have a pretty good relationship with people. I like to consider myself a happy warrior. But I'm a sinner. I have sent nasty emails. I have said things I regretted in deposition. I have treated others like I would not want to be treated myself. That has happened. And, you just have to remember that this too shall pass. This person is doing his or her job, defending his or her client. Your job is to represent you and your client and maintain your humanity and your reputation at the same time. So when I try to be as patient and thoughtful as I can, I fail sometimes. But that's the thinking going in. This person is not evil because they're defending this company or because they're paid by an insurance company. This is their job, and they're just doing their job right now. And treat them like a human being, because you know what? Maybe when the case resolves, they'll send you a case in a year or two. And I have found that that's what we aspire to.
I think one of the challenges, and I'm asking this primarily for myself, is that issue of trying to get the difference between getting sucked into fighting for the fight versus the judo law of well, yes, I can rise to the bait on that, but this one is not worth it. And how, when you're in the moment, either the fray of a heated deposition moment or the back and forth of, I can't believe they are not giving me this stupid, simple document. What do you do, or what have you looked back on and wished you've done that makes it so that you are not turning this into a personal battle?
Yeah, great question. And again, I have failed, and I'm sure I will fail in the future in this. But what I try to do, so depositions get quite heated sometimes. You try to take a break. Let's take 10 minutes. Let's just go outside, take a walk here, and clear the air, and come back. And so that's a reset. And sometimes that works. Sometimes it doesn't. Sometimes it works. Emails are tough. Sometimes you don't just because you get an email doesn't mean you have to respond to the email. Some people don't know that. And so sometimes a non-response is the best response at all. If you get something really shitty, really nasty, definitely don't respond right away. And then you try to kill them with kindness the next day or a day later if it needs a response, or just don't respond at all. But it can be very challenging. I found that discovery, the last few years, I'm not sure it's from the pandemic, but it seems that discovery is getting more and more contentious and more difficult. And my theory is that because fewer people are trying cases, which is a big problem that we're trying to address at ABOTA, but fewer people are trying cases. So those folks that don't try cases do discovery, but they have no idea why they're doing the discovery. They're not doing it for trial because they don't know what's going to come in. They don't even know why they're asking these questions or asking for these documents. It's on some checklist somewhere. Someone told them to get it. So they're taking these depositions and doing this discovery, and they're not sure how it comes into play at trial. And I think because fewer people are trying cases, the discovery is getting worse. The depositions are getting worse quality, and the obstreperous tactics are getting worse. That's my theory.
From a chronologic perspective, this has not been my best interview in terms of going kind of piecemeal, but chronologic also can be kind of dull. One piece I haven't covered in terms of that chronologic piece is when we last talked about a firm, we were talking about Jones Clifford, and you all the work for UPS, et cetera, was with Altair.
We signed UPS up at Jones Clifford. Josh and I did, and then we were at Altair less than a year later.
Okay. And as I understand it, Jones Clifford for forever was what was I thought of as the AAA building. Is that?
Yeah. Was it 100 Van Ness? And then they made that an apartment, and then they moved to Fox Plaza.
And so you had the opportunity of moving with your firm into the same building with, and there's nothing wrong with the city attorneys. They're wonderful people. And there's, I was about to say nothing wrong with Fox Plaza, but
there's a lot wrong with Fox Plaza.
Okay.
Let's just be honest.
So amongst the reasons for your moving on, Fox Plaza was not a great place to be.
Yeah, I didn't love Fox Plaza. That's not the reason I left, but Fox Plaza was kind of a depressing place to work for sure. Yeah.
Well, they've literally lightened it up in terms of the Salesforce light LED show on the side.
Yeah, I think it's a phrase, lipstick on a pig.
Well played. So, but you went over to Altair. You and Josh both went to Altair at the same time.
That's right. Josh came on board at Jones Clifford in 2012. And we got along really well together, and he became a partner there, and we worked together pretty closely. And Craig Peters and I had been friends for a while. Craig was at the Veen firm, and I remember he went back-to-back trials in Solano and Monterey and just got wonderful results. I was just blown away by his results. And I just emailed him to tell him that, and he said, hey, let's have lunch. And we actually developed a friendship where we go to lunch basically once a month or once every other month, just to chat. Because at the time, the Veen was on 711 Van Ness, and we were nearby. And so we were geographically close. We were in downtown. And so we would get together, and we always talked about maybe doing something together. And then the summer of 27, and then at some point, he said, okay, it's time. I'm going to make the move. I'm like, oh, okay. and Anjay and Jeremy are coming. What do you think? I'm like, okay, let me talk to Josh about it. And that's when we moved over together. So that's how it occurred.
Well, Altair certainly has been a guiding star.
Boo.
Well,
you had to.
I actually had to pause to think about it to remember what the translation was. Joking aside, when I think of firms that are inspirations for being prepared to go to the mat, for being able to assist other lawyers who need talent to get the big number in trial, your lineup is astounding, and the results speak for themselves. It's really nice to see the insurance companies get punched in the face in a way where they understand that they have to pay in cases. It lifts all boats when a firm does that.
100%. And well, thanks for the kind words. I work with incredibly talented, hardworking attorneys. Each and every one of them are smart, hardworking, great ethics, terrific in trial, just great human beings. I'm blessed. And yeah, we have decided that we are going to push cases. Obviously, the clients always come first; their desires always come first. But we like to resolve cases. But we don't hesitate to take them to trial if the number is not there, and we think that we can get better numbers often than what the insurance or the defense thinks we can get. And sometimes you win those, and sometimes you lose them. We've been winning some lately, but it's important for anybody in our community to go and get verdicts. Getting verdicts is so important. As a president of San Francisco chapter of ABOTA, ABOTA is very interested in preserving the Seventh Amendment, the right to a civil jury trial, along with professionalism, civility, and integrity. And the civil jury trial is vanishing, and it's becoming more difficult to get trial experience. They're more expensive. They're more complex. They're harder to get. ADR is, prevalent. You show up to trial and the trial judge is looking at you like it's your fault that you're taking up a courtroom. How dare you try a case in a trial department, kind of is the attitude almost. And it's really important that, folks get out and get trial experience, because trial is a muscle that must be exercised. I mean, both for the Seventh Amendment society, it's vitally important. It's what holds people with power in check. You got to do it. And in terms of practicing, you need to have trial experience to get comfortable with taking cases to trial. And your depositions will get better. Your discovery gets better. It's just necessary that we continue to try to get cases to verdict, regardless. And sometimes you win them, sometimes you lose them. But you got to get out to trial.
So what was it like to be sitting at the Trial Lawyer of the Year dinner and be up against your own firm in terms of being a finalist for your trial last year?
I mean, it was great. Craig's an exceptionally talented trial attorney, and his whole team was as well. And Bobby's great, and Doris is great. Everybody, they're all incredibly talented trial attorneys, and it was an honor to get nominated. It probably sounds cheesy and trite. I 100% believe that it was an honor to get nominated. We've got a strong community of highly talented attorneys in the Bay Area. I don't know if you noticed that, Miles. There's a lot of really good trial attorneys in town.
I'm smiling only because I'll tout myself for a second, and the self part that I'm touting is. For those listening, I would love it if they checked out the column I wrote for Plaintiff Magazine this month, because it is exactly on that. And it's on the family tree, on how Picardo and Walkup and Belli and lawyers like that was the best place in the world for trial lawyers. And the learning that was imbued in the trial lawyers here that continues to this day is why we continue to have some of the best trial lawyers in the world.
100%. 100%.
If you're lucky enough to be practicing around here, you have the opportunity to see some amazing people do amazing things.
You do indeed.
So, but I did a little bit of a cheerleader article on that, and yeah, it was really fun to write.
Yeah, I bet. No, when I became the president of the chapter, I actually wrote a note to each living past president, introducing myself. Yeah, it was a cool experience.
Yeah.
Ed Brunson Jr. At that time was 1969 president. He passed away, unfortunately.
I saw that.
Yeah, and we're losing a lot, unfortunately. But It's incredibly inspiring to look at these legends and know how many hundreds of trials they've tried in some cases, and the wealth of trial experience and stories, and the fact that they all did it at the highest level of civility, integrity, and professionalism. And I mean, it's an incredibly array of talented attorneys, and it's really we're blessed to practice in this area.
We are indeed. Going back to the case that got you to finalist, that was a Santa Clara County case, if I recall correctly. Aguilar?
Yes. Yep.
Can you tell us just a high level of the facts of that case?
Sure. Lino Aguilar, at the time of the incident, was a 74-year-old maintenance supervisor. He had retired at age 65, but got bored and wanted to go back to work. And so he was in charge of the janitors at this large Silicon Valley facility called Western Digital. And he's walking out of a building, and he gets hit by a golf cart being driven by a Western Digital employee. He had working for a subcontractor janitorial company, so there's no workers' comp exclusivity issue. So he gets hit by a golf cart. When you get hit by a golf cart, you tend to get pretty badly injured, especially when you're, in your 70s. And he was injured from head to toe. Yeah, he had like 7 surgeries, several $100,000 in medical bills. Still actually having surgeries up at the time of trial, and was 78 when we went to trial in that case.
You got a substantial verdict in Santa Clara County, which is not known for handing out substantial verdicts.
Yeah, Josh and I tried that case together, litigated the case together. We decided to waive economics, and we got $4.5 million for past non-economics and $4.5 million for future non-economics, for a total of $9 million, which is substantial. He had substantial losses that could have had more. They could have awarded more if they wanted to, of course, but it is a substantial verdict, especially for somebody who's 78.
I think a lot of people, ballparky, what was the total of the economic damages that you chose to waive?
They were 3-ish, 2 to 3 million.
The tactic of waiving economic damages is a tactic that I know is frequently used. The tendency, though, that I've seen it done with is when the economic damages are fractional.
Mm-hmm.
I think a lot of lawyers would have had a hard time with the idea of waiving economic damages in a case like that. And obviously it paid off, because I think of Santa Clara jurors, a lot of engineers having a hard time, what algorithm do I use to calculate non-economic damages? Oh, no algorithm, no dollars. So how did you connect the dots? And what made you brave enough to be able to waive that $3 million?
Well, my client was brave to follow our recommendation, which is huge, because often clients, they think, oh, you want us to walk away from $2 or $3 million? Why? And we explained it to them, and they trusted us. It goes back to really knowing your client well, sitting across the table from him and trusting. So we had that incredible level of trust, and so they trusted us on not an insignificant decision to waive the econs. Santa Clara is inundated with engineers. I think we had 3 or 4 engineers on the jury, and so we gave them a formula. We did a per diem analysis based on the defense doctor's hourly testimony. So it's the numbers coming from them, not us. This is their number. And if he gets $1,000 to review records and testify, what does Mr. Aguilar get for suffering this kind of pain, this loss of enjoyment of life, this humiliation? And he had all the 10 categories of non-economic loss that the KC jury instruction defines. We had evidence and a picture or some piece of testimony for each and every one of those. And so we just I went through each and every element, showed him the evidence and showed him, and then we did a dollar figure for it all, like a formula, because I thought that engineering Santa Clara County could follow that. And I think that was a helpful template in that community.
Any other takeaways from that case that you think would be useful for people considering trying a case?
It was challenging because at the very last minute, like 2 days before trial, the defense stipulated to liability. So we had prepared a liability presentation, and they were going to go after comparative. And so that part of the case is over. So it was immediately a damages trial. So that requires some adjustment, of course. And so you still have to somehow try to focus on the defendant's conduct. And we got the judge allowed some testimony about what the defendant was doing. But the important part was kind of load up the damages through other witnesses, not the client. Client went last. So we had the daughter kind of telling the story about his life. He came from Nicaragua, how he built a family. It was quite moving. Great story. Then interspersed that with doctors, family members before and afters. And then he went on for, and Josh did his direct 5 questions. Literally, I think it was less than 10 minutes of direct testimony. I'll never forget just kind of looking at the judge and, there's no further questions. And the judge dropped his pen and kind of looked at us like, what? And so that did 2 things. One, it takes the focus off the plaintiff, which you never want to have the plaintiff be the star of the show in terms of, you don't want the plaintiff moaning and groaning. You want the plaintiff to be a fighter and optimistic, and you have him go last. And the defense attorney they thought we'd probably have my guy on for an hour or 2 hours. They were not prepared I'm sure they were prepared generally for cross, but they were prepared to cross him right then. And so you got to read the room. You're in trial, and the one thing's on paper, but you got to be in the room. And it was pretty powerful. His testimony was quite powerful, even though it was short, because they knew how badly injured he was. And so for the defense attorney to get up and start attacking the guy would not have worked well. And so the brevity of the direct threw the defense off, and the atmosphere of the courtroom was such that he was a terrific trial attorney. He read the room correctly. I really can't go after this guy right now. I'm sure he had some material he wanted to do, but he didn't. So the cross was not, didn't do anything to damage us.
It's those in the moment decisions that can make a big difference in terms of how the case turns out.
Oh, you gotta be able to think on your feet and read the room. I remember a case I tried involving a lawyer, a corporate lawyer, who got out of a car in the middle of the intersection, kind of walked into an area and got hit by a car. Massive comparative fault, and a very challenging plaintiff. He was a friend, but could be prickly, let's put it that way. And so his direct testimony was going to kind of make or break the case. And so where we were in trial, you kind of look at the clock and see, okay, if I finish my direct now, which is way earlier than I wanted to, she's not ready. She's not ready to cross him right now. It's 3 o'clock, 3:15. She's not ready to go. And there's enough time where the judge, she's got to, you got to keep going. So he just said, no further questions. And she was clearly not prepared and didn't do a great cross. So you've got to be able to be flexible in trial.
Yeah, it's when you're in the crucible of the moment that suddenly those next 8 pages of outline are actually not important.
Not important. Yeah, it's important to have the outline, but it's also important to be able to throw out the outline and actually listen to the answers and ask the next question based on that.
Well, we've covered a lot of territory, gone in depth on a couple of your more significant, more recent cases. Is there anything else that you think our listeners should know?
This profession it's a profession. It's not a job. And, it goes back hundreds, thousands of years, really, being advocates. And I think a couple of things. One, keep it civil, keep it professional. Don't treat your opposing party like the enemy. Try to have lunch with that person, have a cup of coffee, meet that person face to face. Who knows? Maybe good things will happen. Maybe you'll have a better relationship with that person. And get into court, get into try cases. It's vitally important, like we said earlier, to get in a courtroom and exercise those trial muscles. We must get it, whether you're defending cases or bringing cases, you've got to get those trial chops and exercise the 7th Amendment and let the community decide cases where we can ourselves and live with that result. So I encourage people to get along with each other as best you can and to get into court and try cases.
Wise words and things that we all should be doing. So thank you very much for taking the time today, Kevin.
Thanks, Miles. I really enjoyed it.
And thank you for listening today. Please email us at podcast@coopers.law with questions, comments, feedback on how you handle economic damages at trial, and suggestions for who we should have on the show. Like what you heard? Share us with a colleague and leave us a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.